I'm not your bro. I'm not your man, and I'm not to be interrupted when I'm speaking. Just because you're unsatisfied with the way that I ruled, then that's not my problem.
Hello, everyone, and welcome back. In today's coverage, we're stepping once again inside Judge Perkins' courtroom, where another unusual legal dispute unfolded. The individual involved identifies as a sovereign citizen and arrived firmly convinced that their personal interpretation of the law outweighs established legal procedure. As the hearing moved forward, it became clear that this belief would be put to the test against real courtroom rules, long-standing statutes, and judicial authority. Situations like this often highlight the sharp contrast between online legal theories and how the justice system actually operates. With that context set, let's walk through what happened, how the court responded, and why this case serves as yet another important reminder of how the law truly works inside a courtroom.
City of Detroit versus Christopher Perry Lewis, case number SP 151-06611. Appearance for the record, please.
Sherika Harris on behalf of Mr. Lewis, please state your name for the record.
I don't have an attorney. I'm representing myself. I articulated that at the last hearing.
Today is the date and time set for a ring on the bench warrant. I'm going to enter not guilty plea on his behalf. I'm going to give him a $0 bond. Mr. Lewis, you said you were here last time. Why did you miss your date?
I actually didn't miss the date. I actually sent you a motion today to show you proof that I was actually in the hearing, and I was locked out of the hearing after an hour of waiting. As well as I sent you a motion for dismissal as well. I sent it last week. Yes, I sent it last week, but I resent it today, and I sent it in a Zoom chat as well to the prosecutor, the clerk, reporter, as well as the clerk.
I didn't get that motion, either of those motions.
Is there any way you have availability to look at the Zoom message, right? I sent it to not only your email, but the Zoom chat as well.
I need it in my email. I don't
sent it twice. I could tell you my email if you want to search it, but you should have it twice in your email. I resent it.
What's your email? What's your email?
Chris, CHRISLEWIE, Midtown, that's MIDTOWN @gmail.
Chris CHRISL, right?
Yes, EWIE.
I don't have it.
The individual, who confidently presents themselves as highly knowledgeable about the law, struggled with a very basic task before the hearing even began. Simple communication procedures, such as properly sending required documents by email, became an unexpected obstacle. This moment quietly underscored a recurring pattern seen in cases like this. While bold legal claims are often made, the fundamentals of court procedure are frequently overlooked or misunderstood. It's a reminder that courtroom success isn't built on confidence alone. The legal system depends on clear communication, proper filings, and adherence to established rules. Details that matter just as much as arguments made in front of a judge.
Okay, I'm resending at the moment.
I'm going to put my email address in the chat and put my email so you'll have it, and send that to me, and I'll have an opportunity to read that. I'll confirm that you sent. I'll wait to confirm that you send it to me, and I'll give you a date. The next court date is going to be a pretrial date on May the 28th, 2024 at 8:30. You need to get a copy of that to the city attorney as well.
I'm actually just sending it to the prosecutor as well. Daya Mason, is that her?
Yes.
Prosecutor? Yes, I did just send her attachment. If she could send me a confirmation that she received it.
Get it to her email address. So Mrs. Mason, you put your email address in the chat as well, so Mr. Lewis can get you a copy of that.
I really appreciate that.
File of that motion, those motions that it has. All right. I'm going to wait on that. Once I confirm that you gave me that, I will recall the case.
After numerous failed attempts and an unreasonable amount of effort, the individual eventually managed to send an email to Judge Perkins. What was treated as a major achievement on his end quickly became insignificant once it reached the court. Judge Perkins needed only a brief glance at the message before determining it held no legal value. Within moments, the submission was dismissed as irrelevant to the proceedings and inconsistent with proper legal standards. That swift decision clearly did not sit well with the sender. The immediate rejection appeared to trigger visible frustration, highlighting once again the gap between personal expectations and how efficiently courts assess and rule on unsupported claims.
Let's go back on the record with Mr. Christopher Lewis. I have received this motion, and I read the first couple of lines of it, and that I'm not concerned necessarily about the March 18th incident. I don't know what happened on that day, but you are here now, so we'll move forward.
Excuse me, sir. I heard you say that you only read the first couple lines. Is there any way we could possibly take another case until you get the chance to read the entire thing? It's only 2 pages.
I'm not going to read this entire thing today.
It's only like 3 paragraphs, the entire thing. The rest are just case sightings.
All right, I'm gonna deny the motion. I will set the matter for.
Is there any way I can get a written? Can I get a written articulation as to why you're denying the motion?
I'm denying the motion because
I would just appreciate a written excuse. Can I get a written articulation?
I might give it to you in writing.
Are we on record? Are we on record?
We're on record.
Okay. Is this court bound by the U.S. Constitution and Supreme Court rulings?
Yes.
Okay, you were denying my motion when I said that I had Fourth Amendment violations, and you're saying that you're denying my motion without looking into it or granting me a hearing to go over my motion, or give me an articulation as to why, a written excuse as to why. I want to make sure that that's what you're saying to me.
You're asking for a change of venue. I'm denying.
I'm saying that I know there's a motion for dismissal, and I'm saying that you, as an Article 1 judge under the Commerce Clause, if you're not going to uphold my due process and my Fourth Amendment, I'm saying that maybe we could change venues where I could get a real judge.
What stood out immediately was the reality of the situation. This was an actual judge presiding over a real courtroom, not a theoretical authority pulled from an article or online source. That distinction matters, and it would soon become central to how the case unfolded. The misunderstanding, however, ran deeper. There is no automatic right to relocate a case, simply because a ruling doesn't go your way. Courts don't operate on personal preference, and a change of venue is not a free pass that can be claimed on demand. Judicial proceedings follow strict rules, and venue changes require specific legal grounds, formal motions, and approval by the court. Disagreement alone isn't enough, and learning that lesson often comes as a surprise to those unfamiliar with how the legal system truly functions.
Okay, I'm denying a motion to dismiss, okay? I'll set a trial date for you so you can be heard on that type of forum.
I insist that the court give me a written excuse as to why you're denying my motion so I can take that to the tenor, okay?
Well, you can insist all you want to.
Okay, I appreciate that. But I'm telling you, you're telling me today why you're not going to look into it or give me a hearing as so I can go over the evidence that I have to present to go with my motion. You don't want to do any of that. So I'm just asking that you can give me a written excuse that I could go take and complain against you on, because that's violating my due process. You didn't even give me the chance to say we're going to schedule a evidentiary hearing or something like that. You're going to sit up here and disregard that when I made genuine claims and put genuine evidence in there. Overwhelming.
If the claims had truly carried legal weight, the case would have been dismissed outright. That didn't happen here. Instead, the motion was denied because it repeated the same familiar sovereign citizen-style arguments that courts have consistently rejected. Judge Perkins needed only a brief review to reach that conclusion. The lack of supporting law, precedent, or valid legal reasoning was immediately apparent upon inspection. This moment reinforced an important point. Courts don't measure arguments by volume or confidence. They rely on established statutes and clear legal foundations, and without those, even lengthy filings are quickly set aside.
So at the end of the day, like I said, there's no crime. This is a fraudulent charge. There's no suspect. Y'all suspect me for no crime. There's no victim, no losses. Okay? and in a minute it's going to be malicious prosecution. So I'm asking you to dismiss this charge or change the venue. And if you refuse to do that, I'm asking you for a written excuse so I can take it to the tenor, sir. That's what I'm telling you. Because if not, I'm gonna go to the tenor without it and let them know that you refuse to give me a written excuse and you refuse to give me an evidentiary hearing, but you just straight denied it. When you just 5 minutes ago, you said you didn't even read it. Now you just denied it. That's conflict of interest. That's bias. That's all that. So let's put it all on record. If you feel just as strongly as you feel, give me a written excuse. If not, let's change venue. Because you're an Article 1 judge under the Commerce Clause. This conflict of interest, you only here to make money, man. You know what I'm saying? It ain't no crime.
Wait a
Ain't
minute.
no
I'm not
victim or
your
no
man.
loss, bro.
I'm not your, listen, I'm not your
Look,
man.
look,
I'm not
sir.
your, oh, beat your
Hey,
bro.
sir. Hey, sir,
Okay?
respectfully, you're an Article 1 judge under the Commerce Clause. You've been on the bench since what, 21? Couple years? You need to talk to some.
The court has already heard similar arguments many times before, presented by numerous individuals who claim to have a unique legal understanding. Despite those efforts, not one of those arguments has met the basic standard required to be considered legally persuasive or valid, unless entirely new and credible legal authority were introduced, something grounded in recognized law and supported by precedent. There was nothing here that would change the court's position. Repackaging the same claims under different wording does not make them stronger or more effective than a result. Today's presentation offered no new legal substance. Instead, it served as another example of how unsupported theories quickly fall apart when examined in a real courtroom, reinforcing lessons the court and observers have already seen many times before.
I'm asking you to give me an evidentiary hearing to go over my motion for dismissal with the overwhelming evidence or change venue. Because if not, I'm going straight to the tenor right after this. And that's on you, sir. You had this. You did this.
Oh, all right. Now I'll let you speak.
Straight like that.
No, that's all we need. I don't want to hear any more
All right,
from
cool.
you.
It's cool. I appreciate it.
Your record.
This due process this a due process violation. This is a due process violation right now. And the way y'all tried to railroad me when I was ready to argue my trial. I told you I was here to argue my trial. Y'all locked me out. Now you're trying to start the process over. They're not prepared to present a case. I'm telling you. They're not prepared to present an injured party, sir. What are we doing?
Listen. Please do not say any more. You've already made your record. I've given you that opportunity. If you continue on, especially interrupting me while I'm talking, because I didn't interrupt you while you were talking. I'm not your bro, I'm not your man, and I'm not to be interrupted when I'm speaking. I gave you the respect and the right to speak. Just because you're unsatisfied with the way that I ruled, then that's not my problem. You
Okay,
take whatever. Wait a minute. Let me say it. You take whatever recourse that you feel that is necessary. Now, what I can do, Mr. Lewis, is I can set you a jury trial date. And at that jury trial date, you will have an opportunity to represent yourself or do whatever you want to do and put all your proofs on the record by a jury of your peers, and you can argue it that way, okay?
When he referred to being judged by a jury of his peers, the statement revealed a fundamental misunderstanding of how jury selection actually works. Jurors are not chosen based on agreement with the defendant's views, nor are they selected to favor one side of a case. The jury is composed of ordinary citizens drawn from the community, tasked with weighing evidence and following the judge's instructions on the law. Their role is to evaluate facts objectively, not to validate personal beliefs or legal theories. Relying on dismissive assumptions about jurors does nothing to strengthen a legal position. In reality, a properly selected jury represents one of the core pillars of the justice system, designed to ensure fairness through collective judgment rather than individual opinion.
I appreciate that, but I would still like a written.
You order the transcript. You order the transcript. It's in the transcript. You asked me to read the couple of paragraphs that you made. Most of the paragraphs was referencing the incident on March 18th, as you and I'm not even debating or disputing it. I said I'm not concerned about March 18th or any missed date. I said that the most of what you're saying is in its it's not, I'm not even gonna hold you to that, but in paragraph 2, moreover, I want to emphasize that the initial charge against me in this court is fraudulent. I don't know that to be the case. That's why I'm giving you an opportunity to have a jury trial, and they can make the determination. Neither the complaining witness or the prosecution is prepared at any point of this case to present an injured party or any reported damages/losses. So it becomes abundantly clear that every proceeding taking place is strictly an attempt to seek funds where there is no crime and not seek real justice. So we are giving you real justice, because if you say that there's been no crime, then you have a right to a trial. And that's what I'm giving you. So I was assaulted, detained, and my property illegally searched and seized with no suspicion of crime at the hands of the complaining witness, Joshua Martin, and assisting officers. I do not consent to these fraudulent proceedings and demand that the court dismiss the charge immediately with the appropriate remedies. And I'm dismissing the motion based on that, because I am giving you a proper forum to argue your case, or allow me the right to change the proper venue of federal court where my U.S. constitutional rights will be upheld and not disregarded by Article 1 judge under the Commerce Clause. I don't understand that.
That distinction doesn't change the outcome, Judge Perkins, because the legal authority involved is being misunderstood. Judges often fall under different constitutional categories, but that doesn't strip them of their power or legitimacy. Article I judges are typically associated with federal courts and derive their authority from Article 1 of the U.S. Constitution. Judge Perkins, however, serves as a state judge, and his authority comes directly from the Michigan State Constitution. That state authority is fully valid and firmly rooted in the 10th Amendment of the U.S. Constitution, which reserves certain powers to the states. In other words, Judge Perkins' jurisdiction is not only lawful, it's exactly how the constitutional system was designed to function. That, if you'd like, I can make future sections even more simplified, more analytical, or more instructional for general audiences.
Indicating a clear conflict of interest, I do not wish to proceed with this matter. You don't have to proceed any further because I'm dismissing the case. He did cite some case law. It was at Sherrar v. Cullen, 481 Federal 2nd 945. For a crime to exist, there must be an injured party, corpus delicti. There can be no sanction or penalty imposed on one because of the U.S. constitutional right. Louisville versus Motley, 211 U.S. 149, South 29 S period court CT 42. Any tribunal court finds absence of proof of jurisdiction over a person or subject matter, the case must be dismissed. The accuser bears the burden of proof beyond a reasonable doubt. All right, so I'm dismissing the motion. All right, and you can get a copy of that record on of what we just made by going through the proper channels of the court to get the court reporter to produce that record.
I can't even get the court reporter to respond to my voice messages or you to respond to my emails, sir.
The court is not going to respond to your voice message. The court reporter is going to respond to you coming down.
The 36th district told me to call her today, that I was locked out of my trial date. I had a scheduled trial. The court told me to call her that day, and I called her that day, and she still hasn't responded. So I'm trying to see if the court that you work for is trying to tell me how the appropriate channels, and then y'all doing it different in y'all court. What am I to do?
I think you're talking about the court clerk and not the court reporter. This is distinct.
Yeah, I was told to call the clerk the day that I was locked out, the moment I was locked out.
We've moved past that getting locked out.
But that was my trial date.
Yeah, so I'm giving you
another. How soon can I get another trial date, sir? How soon can I get another trial date? That's what I'm asking.
That's what we're trying to do now.
A jury trial.
A jury trial. I'm gonna let the jury of his peers hear what he has to say.
At that point, the judge made it clear that accuracy matters, including when referring to the parties involved. Courtrooms operate on the record, and names, titles, and procedures are expected to be handled correctly at all times. Before concluding the session, Judge Perkins delivered one final remark that underscored his authority and control of the courtroom. It was a brief but pointed reminder that proceedings move forward on the court's terms, not based on personal commentary or distractions. With that, the hearing wrapped up, bringing this chapter of the case to a close. As you can see, I'm back from my trip and ready to get back into the work. I want to sincerely thank everyone who continued watching the videos while I was away. The comments you left during that time genuinely kept my spirits high and made the entire trip more enjoyable. I truly appreciate the support and always look forward to reading your thoughts on every video and live stream I share. If you enjoyed the video, go ahead and hit the like button. If it wasn't for you, the dislike button is there as well. Either way, don't forget to leave a comment.
July 23rd, 2024 at 9 a.m.
July 23rd.
Yeah, 2024 at 9 a.m. We'll have a final pretrial the day before.
Why would we need a final pretrial? Why would we need a final pretrial?
Because I said I wanted one.
But that's how you protecting your interest. You protecting your interest, and you're gonna dismiss it on that date. So you're trying to play with me. You could dismiss it today, sir. You literally, but
a final pretrial 8:30.
You are literally violating my due process. You can't even give me a written excuse, but you're gonna all this whole.
Mr. Lewis, I know you don't want counsel, but is it possible we could talk in a breakout?
Excuse me, ma'am. Excuse me, ma'am. I am in pro se. I'm in pro se.
Go wherever you want to. Final pretrial of July 22nd. And final date is going to be July 23rd. All the parties must appear on the final pretrial date, and the jury, and that can be on Zoom. And the next day, the jury trial date is in person. Have a very good day, Mr. Green. Best of luck to you.
That's not my name.
Put him out the room, please.